Welcome everyone. Let's dive into the background of our country, the United Arab Emirates, where we can learn about their rules, regulations, diversity, and employment procedures. Islam is the official religion, and Arabic is the official language. It is the home of immigrants from all over the world. This may be because the UAE nationals prefer to work for the government or military. Emiratis are outnumbered in their own country by a ratio of 4 to 1, which is 20% of their population. Each emirate is governed by a sheikh, and together they form the Federal Supreme Council. One of them serves as President of the United Arab Emirates. In 2013, the UAE's population was 9.2 million, of which 1.4 million were Emirati citizens and 7.8 million were expatriates. The estimated population in 2020 was to be 9.8 million. The UAE oil and natural gas reserves are the sixth and seventh largest in the world, respectively. The UAE economy is the most diversified of all the members of the Gulf Cooperation Council. While its most populous city, Dubai, is the global city and international hub, the country has become less reliant on oil and gas and is economically now focusing on tourism and business. So let's now focus on the individual employment contract. Under Article 35, the employment contract shall be written in duplicate, one copy handed to the worker and the other to the employer. Should there not be a written contract, all conditions thereof may be established by all legal means of evidence. Article 36. The employment contract shall determine in particular the date of conclusion thereof, the date of commencement of work, the type, location, and duration thereof. Should it be of a determined period as well as the amount of wage. Article 37. The worker may be employed by a probation period not exceeding 6 months, where the employer may terminate the services of the worker without notification or end of service gratuity. The worker may not be employed by the same employer for more than one probation period. Should the worker successfully complete the probation period and persist in his job, the said period shall be deemed as a part of the service period. Article 38, it states that the employment contract shall be determined or undetermined term. Should it be for a determined term, it may not exceed 4 years. Such contract may be renewed by mutual agreement of the parties for one or more similar or shorter terms. Should the contract be renewed, the new term shall be deemed as extension of the original term and shall be added thereto the upon calculation of the total service period of the worker. Article 40. Should the parties pursue the application of the contract after the expiry of the original period thereof or the end of the agreed job without an explicit agreement, the original contract shall be deemed implicitly extended under the same conditions mentioned therein within the exception of the term. Article 41. Should the employer subcontract a third party for the performance of any of the original tasks or part, the latter shall be solely liable for the rights of the workers thereof carrying out such subcontracted tasks in pursuance of the provisions.
General Provisions, Article 2. Arabic shall be the language used in regards to all records, contracts, files, data, and other provided. Arabic shall be the language used in the instructions and circulars issued by the employer to his employee. Article 3. Employees and workers of the federal government and the government departments in the Emirates, members of the state, the employees and workers in public entities and institutions. B. Members of armed forces, policies, and security. C. Domestic servants in private households and similar occupations. D. Workers in farms and pastures, with exception of persons working in agricultural institutions, processing the products thereof, or the persons permanently operating or repairing mechanical machines required for agriculture. Labor regulations and policies. The employer must pay for the recruitment costs and travel to the UAE. The employer must pay for the residency permit. Keep the receipt of for anything you are asked to pay for. Keep a copy of the signed job offer. The contract must match the job offer. The employer is entitled to keep the personal identification documents with you all the time. No work upon arrival or not receiving wages on time and in full, report it to the labor office. Contract and personal identification. The employer must present you with your employment contract for signature. The employer needs the personal identification documents in order to and for the first time required to obtain the residency permit. The working hours. 8 hours in the normal working hours per day, 9 hours in the normal working hours per day for commercial business like catering business, gardening business, hotel business. 6 hours on the normal working days in Ramadan. There is 1 hour rest in between the working hours. Overtime. Maximum overtime a day is 2 hours and it can be extended to prevent major loss. Calculation of overtime. In normal days, overtime between 9 p.m. 25% of the total salary, 2 hours overtime maximum. In normal working days, overtime over after 9 p.m. to 4 p.m. 50% of the total salary, 2 hours overtime maximum. On Fridays, 50% of the basic salary calculated as per working hours. On holidays, 50% of the total salary in addition to compensating another working days off. In case not compensating another day of 150% of the basic salary. Holidays. Pilgrimage leave 30 days once without pay. Weekly holidays Fridays. Annual leave 30 days a year within the total salary. Sick leave 90 days as follows. First 15 days full paid salary. Next 30 days half paid salary. More than above no salary. Probationary period 6 months in the UAE. Anything exceeds 6 months is unlawful. According to the UAE labor law, the employer has to bear all the visa expenses and cannot ask for any expenses from the employee.
So let's now see the professional training contract for the employees. Under Article 42, the professional training contract is the contract whereby the owner of the establishment undertakes to give complete professional training that is consistent with the standards of the profession to a third party having completed at least 12 years of age. The latter shall in turn undertake the work during the training period for the employer in accordance with the condition and duration agreed upon. The training contract shall be in writing, otherwise it shall be deemed void. The employer or the trainer shall enjoy sufficient qualifications and expertise in the relevant profession or craft which the training is made. Furthermore, the firm must itself meet the technical conditions and capacities necessary for the provision of such training on the profession or craft. Article 43. The trainee having reached the maturity age shall conclude the contract by himself. Whoever is under 18 years of age may not enter into a direct contract with the employer for the training. The trainee shall be represented by the parent, legal trustee, or guardian. Article 44. If the training contract shall be made in 3 copies at least. One copy is deposited with the competent labor department for registration and authentication. Each party shall keep an authenticated copy. Should the training contract to be authenticated contain a provision that contradicts the law, the regulations, executive decisions issued in the application of the provisions, the competent labor department may request that the contracting parties delete such breach. Should the competent labor department not express any observation or objection within a period of 3 months, the deposition of the training contract therewith, the contract shall be deemed duly authenticated as the date of deposition thereof. Article 45, it states that the training contract shall include particulars regarding the identity of the contracting parties of the Article 45, the training contract shall include parties Article 45, the training contract shall include particulars regarding the identity of the contracting parties or the representatives thereof, as the case may be, the method of training, duration, Article 45, the training contract shall include particulars regarding the identity of contracting parties or the representatives thereof, as the case may be, the method of training, the duration and phases and subject of training. Employer 46. The employer shall grant trainees sufficient time to receive thereof training. He must train the worker on the profession standards and skills for which he is recruited and such for the period set in the contract, and must grant the trainee a certificate upon the completion of each phase of training in accordance with the provisions set forth in the present chapter, and a final certificate at the end of the training period. Such certificate may be authenticated by the competent labor department in accordance with the principles and procedures determined by virtue of a decision issued by the Ministry of Labor and Social Affairs. Article 47. The worker may undertake in the training contract to work subsequent to the completion of the training period for the employer or in the establishment where the training period took place, and such for a period not exceeding twice the training period. Similarly, the employer may undertake in the training contract to employ the worker subsequent to the completion of the training period. Article 48. Payable wages for every phase of the training shall be determined in the training contract. Such wages paid in the last phase must not be less than the minimum set for a similar work, and shall under no circumstances be determined based on the piece of production, piece or the production. Article 49. The trainee whose age is less than 18 years old shall undergo a medical examination to assess the health condition and capacity, and thereof to carry out the task and of the profession for which a training is to be given, and such prior to the commencement of the training thereof. Should such a profession require special physical and health conditions, the medical report shall mention the meeting by the trainee candidate of such conditions, being physical or psychological. Article 51, it states that the Ministry of Labor may decide to establish centers for the professional training, whether independently or in cooperation with the professional or philanthropic, national, foreign, or international entities. The decisions issued for the establishment of the center shall determine the profession for which the trainee is held, the conditions of admission in the center, the theoretical and practical programs, the examination systems and professional certificates, and the any other provisions necessary for the good operation of the center.
UAE visa procedure. Stage 1. Obtain the employee entry visa in UAE. Visa quota approval. The first step towards getting the entry visa is to get visa quota approval from the Ministry of Labor, and the employee will apply the behalf of the employee. If the visa for application in any of the free zone, quota approval must be granted before the employee enter in the UAE. Job offer, contract and signature. The next step is setting the job offer contract of the employee signature and having them written of the employer. If you must, the English and Arabic will be the employee's native language. Work permit approval of application. Before the entry visa issued, the work permit application must be approved during the approval process. The Ministry of Labor usually bases its decision on the whether there are no unemployed UAE citizen and could perform the job. The sponsor of the registered UAE corporate entry, employment entry visa. Upon receipt of the permit approval, the ministry issued an employment entry visa, also known as the pink visa, which allows application to legally enter the UAE. Stage 2, obtain the work permit and registered visa in UAE. Entry to UAE new entry permit. There are two options to enter the country after being the work permit process. If the entry visa was ready period of arrival, the employee picks on arrival the airport. If the employee was already in UAE on another type of visa, medical screening. The UAE requires all foreigners to get the medical screening before the work permit can be issued. Emirates ID application. The employee then needs to go to the Emirates ID service center. After getting the relevant for type of at the any type center and original valid passport and employment entry permit are required to apply for the ID and have the biometric downs. Medical screening result. The medical screening result have the obtained the include in the application. Labor contract signature. A signed labor contract must allow to be submitted as part of the work permit application. There is no deadline for the contract and the must be sent to the MOL within 14 days following the issuance of medical results. Receipt of labor card. Work permit contract with start date of the work permit required, that is when payroll of officially start the official UAE system. Medical health insurance card application. Because health insurance is now mandatory in UAE, all employee must provide coverage for the expect workers. The work permit cannot be issued or renewed without the valid insurance card. Resistant visa stamping in passport. All expect work and their family members will need the resistant visa to legally live in UAE. The visa required to open bank accounts. Emirates ID collection. In addition to the work permit, the employee will receive an Emirates ID card, which is the useful for everyday identification purpose. Title 6. Disciplinary rules. Article 102. Warning, fine, suspension with the reduced pay the period not existing 10 days. Article 103. The disciplinary rules shall determine the case of the each disciplinary sanction set forth in the proceeding article shall be implemented. Article 104. The fine may be specific amount or an amount equal of the wage and worker for a specific period. The fine procedure of regard to the breach may be not exceeding the wage of 5 days. Article 105. Fine imposed on workers shall be received the special register along with the case of the circumstance of imposition thereof, as well the name and wage of the worker. A special account shall be allocated thereof, and any monthly proceeds thereof shall be used for the social welfare of the worker in accordance with the decision used by the Ministry of Labour and Social Affairs in regard. Article 106. The penalty of depreciation, the period allowance may only imposed with per year. Such allowance may be not a difference for the 6 months. Article 107. The penalty of deprivation, the promotion may not be imposed for the more than one promotion cycle. The penetration work shall be the promoted during the following promotional cycle should be not necessary condition for such promotion. Article 108. The financial difference from the deprivation, the promotion allowance that determine thereof, the employer shall register the special registration along with the case of the circumstance and the imposition well as the name and wage of the worker. Article 109. No disciplinary sanction may be imposed to the worker for an act perfectly thereby outside the workplace unless such act the connect to the network of the employee or the responsible manager. Article 101 shall be not the permissible to impose the worker any the section set in Article 102 unless after the notification there are the writing with the regard the charge made against him after having had work and the defense thereof investigated and the having a record to the matter a minute deposit in his personal file. The section shall be noted into the such a minutes. Article 111. The worker may not be accused of the disciplinary defense offense of their day of discovery thereof. Furthermore, no disciplinary section may be imposed after 60 days from the date of the end of the investigation to the offense which of the work in for quantity. Article 112. The work may be temporarily suspended from the work upon the charging thereof a deliberate crime against life, property, honor, honestly carrying out of strike. The suspension period shall commence of the date notification of the incident to the competent authorities and until the issuance of the decision thereby in such a regard.
Records and files. Article 53. The employer employing 5 or more workers shall observe the following. Keep a personal file for each worker mentioning the worker's name, profession or occupation, age, nationality, address, marital status, date of employment, wage, and any adjustment thereto. Penalties inflicted thereupon, occupational injuries and diseases sustained thereby, as well as date of termination of service and reasons thereof. Prepare for each worker a leave card deposited with the worker file. Such card shall be divided into 3 sections: annual leaves, sick leaves, and other leaves. The employer or the representative thereof shall record on such card the leaves taken by the worker and such of for reference upon the request for any leave. Article 54. The employer employing 15 or more workers shall keep in every work location or branch the following records and documents. Payroll, in which the name of the worker are mentioned in accordance with the document of the employment thereof, as well as the amount of daily, weekly, or monthly wage, fringe benefits, or the wage by piece or commission, the days of work and the date of the final termination of work. Occupational injuries record, in which occupational injuries and diseases are recorded for such upon the knowledge thereof. Basic work regulations. It shall contain in particular the daily working hours, the weekly rest period, holidays, as well as the necessary measures and precautions taken for the prevention of occupational injuries and fire hazards. Such regulations shall be placed in a prominent place at the work site. The implementation of such regulations and the amendments thereto shall require the approval thereof the Labor Department and such within 30 days from the date of submission thereto. Disciplinary measures. To be placed in the prominent place at the worksite, they shall include the penalties to be imposed on defaulting workers and conditions and cases of such imposition. The implementation of such measures and amendments thereto shall require the approval thereof by the Labor Department and such within 30 days from the date of submission thereof.
Article 113. The employment contract shall be terminated in the following case. Should the parties dare to agree to the terminator, therefore, provide that the consents of the workers in a written. Should the specific team contract expire unless the contract is explicit or implicitly extended the accordance with the provision herefore. Should the parties to an employment contract with undermined terms with the termination thereof, provided that such parties abstain by the provision thereof related to the notification and the acceptance ground for the termination of the contract is non-arbitrary manner. Article 143. Should the worker contracts any of the occupational injuries of decrease listed in the schedule 1 and 2 enclosed therewith, the employment of representative thereof shall notify the incidents immediately to the police and the labor department or branch therefore within those justifications with the workplace located. Such notification shall include the name, age, occupation, address, and nationality of the workers. The synopsis and circumstances of incidents of medical and or treatment providers. Upon the reception of notification, the police shall carry to the necessary investigations and records in a minute the statements of witness. The employers or the representative thereof and the injustice should the state so allows such minutes shall indicate in the particulars whether the occupation deliberates or arise from the gross misconduct of the workers. Article 154. The collective labor's dispute shall be any duplicates arise between the employers and the workers thereof, whose subject is related to the common interest of all the same of the workers is a establishment on professional and craft on the professional sector. Article 155. Should the dispute occurs between one or more employees, all the same workers, thereof and both parties fail to settle in amicable, they shall follow the following procedure. 1. The workers shall submit their complaint or claim in written to the employers and shall send at the same time a copy thereof the labor department. 2. The employer shall reply in the returns of complaint or claim of the workers within 7 working days at the date of receipt thereof. He shall at the same time send a copy therefore and labor department. Article 166. Labor inspection shall be carried out by specialized inspector affiliated to the Ministry of Labor and Social Affairs. They shall have power and jurisdiction of forth herein. Labor's inspector shall carry courts starting with capacity issued thereto by the Ministry of Labor and Social Affairs. Article 167. Each labor's inspector shall be have jurisdiction to carry out following. A. The supervisor's property claimants with the provisions thereof, namely the provisions related to employment terms, wages, and protections of workers during the performance their work and much related to the health and safety of workers and the employment of youth and women. B. Grant the employment works the techniques information instruction and enable them adopt the good measures in view the existence of provision of the law. C. Notify the contents authority of the lake that the effective provisions for the address and suggest necessary measure thereof. Article 181. Article 181. The amendment by the Federal Law Number 8, date 13/11/2007, without prejudice any service parental provided for the any other law, shall be sentenced to imprisonment and the fine amounting to 10,000 derivatives of least or either rentals. 1. Whoever breaks any implement provision thereof of the executive regulations of decision issued application, therefore, whoever hinder and prevent attempt to stop executive interest with the implement of provision thereof the executive regulations of decision issued is application, therefore, from professional issue duty, whether the thought actual threat of force of violence.
Wages. Article 55. Wages shall be paid on a working day at the end work site in the national currency of the state. Article 56. Workers' employed in return for annual or monthly wage shall be paid at least once per month. All other workers shall be paid at least once every fortnight. Article 57. The daily wage of workers employed on the basis of the piece shall be calculated as the equivalent of the average daily wage received by the worker for the effective working days during the 6 months that precede to the termination of the service. Article 58. The payment to the workers of the wage due thereto, regardless of the value or nature thereof, may only be evidenced in writing or by means of admission or oath. Every agreement made in contrary thereto, even if made prior to the coming into force of the present law, shall be deemed void. Article 59. The worker may not be required to purchase food or other goods from certain stores or from the products of the owner. Article 60. No sum may be deducted from the wage of the worker in return for special rights unless in the following cases: the recovery of any advances or sums paid to the worker in excess of his entitlements, provided that the deducted sum does not exceed, in such cases, 10% of the periodical wage of the worker. Installments legally payable by the workers from the wages thereof, such as the social security and insurance systems. Contributions of the workers in the saving fund or loan due thereto, installments of social project or any other privileges of services granted by the employer and approved by the Labor Department. Fines imposed on the worker for any breaches perpetrated thereby. Even every debt paid in application of the judicial ruling, provided that the sum deducted in the application of the ruling does not exceed 1/4 of the wage due to the worker. Should there be a numerous debts or debtors, the maximum deduction shall be equal to the half wage, and the sums required for retention shall be proportionally distributed among the beneficiaries after the payment of the legal alimony debt at the rate of the 1/4 of the wage. Article 61. Should the worker cause the loss, damage, or destruction of tools, machines, products, or materials owned by the employer or under the custody thereof, and such due to default or breach by the worker or instructions of the employer, the latter may deduct from the wage of the worker the necessary sum for the repair or restoration thereof, provided that the sums deducted for such purpose do not exceed the wage of 5 days every month. The employer may request to the competent court via the competent Labor Department the permission to deduct a longer sum should the worker have money or another source of income. Article 62. The employer may not transfer a worker paid on monthly basis to corps of daily workers or the corps of workers paid on weekly, hourly, or piece basis, and such without a written consent therefore. Article 63. By virtue of decree, law issued upon the proposal of the Ministry of Labor and Social Affairs and consent of the Cabinet, the minimum wage and cost of living index shall be determined either in general or for a particular area or a particular profession. Minister shall submit his proposal to determine or reconsider the minimum wage upon the consultation of the competent authorities and professional entities of the employers and the workers, if any, and based on the studies, the tables and fluctuations of the cost of living set by the competent authorities in the state in view of ensuring the minimum limits are sufficient to fulfill the basic requirements of the workers and guarantee the livelihood thereof.
Article 91. The employer shall provide the workers with the adapted protection means against hazards of occupational injury and disease that may occur during the work, as well as against fire and other hazards resulting from the use of machines and other work tools. The employer shall also adopt all other safety measures set by the Ministry of Labour and Social Affairs, and the workers shall use the safety gear and clothing supplied thereto from such purpose. Article 92. Every employer shall display in the permanent place in the work site detailed instruction related to the measures taken from the prevention of fire and the protections of worker for the hazards that they may face during their performance of the work. Such instruction shall be in Arabic and in another language that the worker understood whenever necessary.